Okay, why don't we start? My name is Brian Burkett. I'm counsel at Fasken. Um, Off the top, I first want to thank the ICGN for hosting this Fasken-sponsored event. The ICGN is an extremely credible organization that has been helpful at every turn in producing this session entitled The Push to Regulate Corporate Human Rights Behavior. So quickly, here's how we intend to proceed over the next hour. I will briefly introduce the panelists in the order in which they will be presenting. I will also have just a few contextual remarks to, as you will, set the table for the panelists. Then we will hear from first Rachel Davis on non-North American developments in the social or the S space of ESG. Then Chris Pigott, running parallel to Rachel. Chris will speak to North American, the US and Canada developments in this same space. And then finally, Brent Wilton. He will comment on the impact of these external social developments, canvassed by Rachel and Chris, on corporations and investors, and in particular, their human rights behavior. Lastly, there will be some time for questions and answers. In that case, I would ask that you put any questions that you have in the Q&A box, not in the chat. And we will try and answer those questions at the end of the hour, towards the end of the hour. So with that process in mind, let me situate ourselves before turning this over to Rachel. So this session is not dealing with the E, the environmental, or the G, the governance aspects of ESG. Here we're dealing with the S, or the social, the least understood, in my view, of the three, E, G, and S. The S, or social component, is essentially about how the corporation interacts with its people constituencies, of which 5 come immediately to mind. First, you have shareholders and investors. Secondly, you have employees and workers in the global supply chain. Thirdly, you have communities where the corporation operates or maintains activities. Fourthly, you have consumers. And fifthly, you have civil society. And by that, I mean NGOs, trade unions, etc. The way in which the corporation interacts with these main people constituencies, that's what makes up its human rights footprint. The foundational international instrument around which international discourse has taken place over the last decade or more is the work of Professor John Ruggie and his team, and is known as the UN Guiding Principles on Business and Human Rights, which was passed in 2011. And it's built, as this audience will know, but worth repeating, 3 main pillars. First pillar, states or governments' duty to protect human rights. The second pillar, businesses' duty to respect human rights. Hence the concept of business and human rights, or BHR, which is nothing other than the S, the social, in ESG. And then thirdly, the third pillar, access to remedy. So there, I've just set the table. I want to now turn things over to Rachel Davis, who was a key member of John Ruggie's team. She is a co-founder of Shift, along with Carolyn Reese, the Ruggie team that assembled post-passage of the UNGP with the purpose of operationalizing that fundamental international instrument. So Rachel and Shift are recognized as a preeminent presence in the social field and we are most fortunate to have her on the panel. Rachel, on that note, let me turn it over to you.
Thank you very much, Brian, and to ICGN as well for the invitation to be with you all today. For those of you who don't know Shift, we're a non-profit mission-driven organization. And as Brian said, our focus and our touchstone is the UN Guiding Principles on Business and Human Rights. And I lead Shift's work to really drive the UN GPs into standard setting of all kinds. In the first decade of the UN Guiding Principles, that was really into voluntary standards at different levels in the reporting space, nationally and internationally. It's now increasingly mandatory standards, and that's, of course, our focus today. I'm going to share a few slides with you, which ICGN will kindly help run. So if you could just bring those up, fantastic. And my job, as Brian has said, is to talk a bit about the emerging regulatory landscape on business and human rights, which is, as he has also said, the S in ESG, but to focus outside North America. And it's really, you know, if you needed a hint, it's there in the flag. The developments are really happening in the EU, and that's where a lot of our energy at Shift is focused at the moment. I lead our work to engage governments, EU institutions, business, investors, and our civil society allies to positively influence the adoption of EU standards that are aligned with the UN Guiding Principles. And I think the good news, as we turn to the detail of this, is that indeed the UN Guiding Principles and the OECD guidelines for multinational enterprises, which align closely with them, are heavily influencing the developments that we see at national and regional level and international level. But influencing is not the same as perfect alignment. And for those companies, and there's a growing number of them that have invested in these international standards for more than a decade now, it's alignment that really matters. So let me dive into the content. If we go to the next slide, please, Chris. I wanted to start by talking about the different types of regulatory or mandatory approaches that we are seeing that draw on the international standards, and focus particularly on three broad types. The first, and I think what we've seen, you know, in play for some time now, is in the area of reporting. But what we're increasingly seeing is proposals and hard law that integrates what we would consider comprehensive human rights due diligence, meaning that it's not just about a specific issue like forced labor or applies to a specific value chain like conflict minerals, but it's really looking at due diligence across the full spectrum of risks that a company may be connected to in its own operations or in its value chain. But we're also seeing developments in this sort of third type of measure, which we call results-based measures. And the example there is the import ban experience in the US, which our next speaker will talk more about, I'm sure. But also now there's a proposal along similar lines at EU level, which I'll speak about in a minute. And the reason why we frame these as results-based measures is because they seek exactly that, a specific result. And if you cannot demonstrate that result, then there are, you know, appropriate sanctions and enforcement actions that happen. Due diligence, of course, is different. It's a standard of conduct that, while it's about seeking to achieve certain outcomes, certain results for stakeholders in terms of respect for their human rights, it doesn't hold companies to producing that result or controlling that result in every case, because it recognizes that would not be reasonable. And so what's interesting, I think, as we move forward in this mandatory phase that we're now in, and which will probably increase, is to see how these measures can complement one another and to see the benefits on the one hand of results-based measures, the benefits of due diligence legislation, the benefits of reporting legislation. But to achieve those benefits, their objectives really need to be aligned, and the implementation needs to be aligned around the principles that have been established in the international due diligence standards. If we go to the next slide, I'd like to take a few minutes to talk about some of the proliferation of developments that we see, particularly, and I'll focus on the ones that are outside North America and particularly in the EU. So as I said, on reporting, many of you in the audience today, I'm sure, will be familiar with the Modern Slavery Act, first in the UK, now in Australia. Worth noting that Switzerland is also moving in that direction by adding forced labour to the regulatory reporting requirements that they have already on child labour and conflict minerals. But I think developments at the EU level really show the way forwards. The Corporate Sustainability Reporting Directive, the CSRD, has been revised and adopted, and there is now a fairly intensive process to develop technical reporting standards under that, which would apply, as the title suggests, to sustainability reporting. So that cuts across E, S, and G. Again, our focus today is the S. And this has caused, I think, some consternation because, as many of you will be aware, the EU had already moved to require reporting in the investment space of investment managers, and I think had tackled that before it tackled reporting by companies across a range of other sectors. So these two developments need to come a bit closer together, and people are already talking about how next year there'll be a need to slightly adapt or adjust what is required from investment managers in order to make sure that it aligns with what's required from real sector companies under the new CSRD. When it comes to comprehensive due diligence, we've really seen this stimulated by national adoption of mandatory measures. So 2017 in France, the Loi de Vigilance, last year, 2021, the German supply chain due diligence law, and a law in the Netherlands currently on the books which applies just to child labour, but actually has not yet been enforced and is the subject now really of a renewed proposal, a renewed set of efforts, both from the Parliament and from the government, to replace it with comprehensive due diligence, as I was saying before, rather than issue-specific due diligence. Norway also has an approach which blends a little bit between reporting and comprehensive due diligence, in terms of the mechanisms for enforcement, but all of these national laws, again, are influenced by the international standards, although they have slightly different scopes of application, apply to different aspects of the value chain, and it's that has really led to the call for a level playing field at EU level. And the instrument that's being debated there is the Corporate Sustainability Due Diligence Directive, or the CS3D. We like to give everything an acronym in the world of business and human rights. And I'll say a few more words about that in a minute. The final sort of cluster of developments, as I said, are these results-based measures. In the US and North American context, it's in the form of an import ban. I'll leave that to Chris Pigott to say more about. In the EU context, what's being proposed is a forced labour regulation, which involves a product withdrawal mechanism. So the main difference there is that rather than impounding goods at the border and then allowing for their release potentially based on evidence of remediation of the harm, this would involve removing products, so sort of sampling through enforcement and then removing products that are seen or can be shown to have been made with, in whole or in part, with forced labour from the shelves or from the single market. So slightly different mechanism. There's some quite strong debate about whether what's been proposed in the Commission's draft in this with this initiative really goes far enough to make sure that we would see remediation for the workers who are affected by forced labour in these value chains. Certainly our view at Shift is that currently it doesn't. And so there are some there's real need for greater alignment between the objective of that instrument and the objective of the Corporate Sustainability Due Diligence Directive. If we go to the next slide, I want to spend a little bit of time on that directive because it really is the most important development, I think, that we've seen to date to drive the UN guiding principles into regulatory requirements of a broad range of companies across different sectors and to some extent of different sizes. And it seems very clear from the direction of the debate, which we are closely involved in as Shift. I was in Brussels a couple of weeks ago speaking at a public hearing in the European Parliament on this, that there is a lot of momentum to reach a result. Now, that still might take some time. The way that the EU legislative process works, as many of you may be aware, is that it requires the Commission and the Parliament and the Council of Member States to all agree on their own proposals and then to negotiate in trilogue on a final result. So it may be that we could hope to see a final result by, say, the end of next year. Then, of course, there would be a period for further transposition and implementation, and happy to take questions on any of that. But I think what we see very clearly is that we are going in the direction of an instrument. And the question is, how aligned is that instrument with the international standards and the UNGP specifically? So what the Commission has proposed, put forward earlier this year, is reflected here in this summary. This is not necessarily where the instrument will end up, as I've just explained. But I just wanted to highlight the main features of the draft proposal. So first, it establishes a duty for companies to undertake sustainability due diligence. That covers actual and potential adverse human rights and also environmental impacts. And that's important, obviously, because I think what we see at the moment is that there isn't really such a thing as sustainability due diligence. There is human rights due diligence. There may be biodiversity due diligence, climate due diligence, water due diligence, chemicals due diligence, that there's many different types of sustainability due diligence that companies are carrying out, but these are not necessarily or typically thought of as a sort of a coherent set of processes. And both on the reporting side and now on the duty to do due diligence side, that's the movement we're starting to see. In terms of the scope of this due diligence, so where should companies be applying it? The draft proposes that it applies to the company's own operations, its subsidiaries, and in established business relationships. This concept has received a lot of pushback from stakeholders right across the spectrum, from governments, importantly from business and business associations themselves, and from civil society. Nobody is happy with this concept. And I think from the tenor of the discussions in the Council and the Parliament, it seems like it will be reopened, whether this is really a useful way of approaching things. The way that the international standards ask or expect companies to carry out due diligence is to cast a wide lens across the full value chain without using any kind of limiting concepts like established business relationships, which frankly lend themselves to being gamed or to having endless questions raised about whether something fits in that category or not. So what the guiding principles expect is go broad, look across your whole value chain, and then prioritize on the basis of where impacts may be most severe to affected stakeholders. So that's an important difference, and we really need to see that come closer into alignment with the international standards as this moves forward. The second point, a word on scope, it applies to very large EU and non-EU companies that operate in a single market. It's sector agnostic in that regard. And then it applies to large companies in 3 higher risk sectors involving minerals, apparel, and agriculture. But in the draft that was already proposed by Lara Walters today in Parliament as part of this sort of parallel process of the different EU institutions proposing amendments, she has already included tech as another high-risk sector. There's also a debate about including the financial sector as a high-risk sector. The draft importantly provides for enforcement through 2 different mechanisms, through civil remedies for people who are harmed by a breach of the duty. And this connects to some, or should connect to some well-established concepts of fault-based liability and through where you can show a causal connection to harm. But also through administrative oversight of compliance, whether or not harm occurs. So there will be a significant expectation on member states to set up or add new mandates to existing administrative authorities to carry out this kind of supervision. We know, for example, that Germany is already doing this for its supply chain due diligence law, hiring, I think at last count, something over or around 400 people into its administrative agency to carry out this function. Not every member state will be able to put that kind of level of resource to this. Fourth element to highlight is that it requires companies to establish transition plans to address climate risks, but climate is not included as part of the general or overarching due diligence duty. So that's an important carve out. And fifth, and quite controversially in the discussion, at least, controversially for some stakeholders, the proposal seeks to clarify that existing directors' duties should include taking account of the sustainability impacts of their decisions. Again, happy to say more about that in the discussion. If we go to the next slide, just a word on Shift's perspective on the proposal. So we strongly welcomed this. We think it is a really pivotal moment, as I've said, in the progress towards mandatory measures that actually can give us markets that truly require and reward sustainable business practices. And this is indeed what the guiding principles envisaged. As Brian said at the beginning, you know, the first pillar of the guiding principles is states meeting their duty to protect, and that can include, where necessary, regulating corporate behaviour. It's also appropriate for the EU in particular to be doing this because the rules for the single market should reinforce EU values, including on human rights, which the EU has been standing up for quite recently in the situation in Ukraine, for example. And the objectives of the directive, we think, are the right ones. The challenge for us and for many other stakeholders, including businesses and business associations who've been quite vocal about this, is the need for the directive to be more clearly aligned with the UNGPs. And this is necessary really to avoid fragmentation of this global due diligence standard, which we fought, and many fought very hard, and none more so than John Ruggie to secure back in 2011. And to really recognise the last decade of investment, as I said, by stakeholders and particularly by leading companies in the international due diligence standards. If we go to the next slide, we have a full detailed analysis of the proposal. You can find this on our website. I'm not going to spend time going through it now, but if we come to the last slide, I just wanted to reflect a little bit on you know, what we see from the Shift side when we look ahead. And without preempting what Brent will share with us, of course, from his expert perspective, that I think it's clear that all efforts that companies make to implement the UN guiding principles will help them prepare for compliance with these coming due diligence standards, certainly the ones that I've been talking about in the EU context. But it's not yet entirely clear whether the reverse will be true. So for companies that have committed and have already been investing in the UN guiding principles, there is this risk of misalignment. There is this risk that these standards somehow require less focus on the full value chain, that they don't allow for prioritization on a principled basis, as I was saying before, so on the basis of severity of risks to stakeholders, that they also confuse, for example, the focus of who we mean when we talk about stakeholders. Brian was rightly saying at the start that there are quite different categories of stakeholders that are relevant when we look at business and human rights. When we look specifically at the expectations of human rights due diligence, it's an even narrower group. So it's the categories 2, 3, and 4 that Brian was mentioning. So it's employees and workers in the value chain, it's local communities, and it's consumers and end users. When you're carrying out due diligence, that's where you're looking for impacts. And NGOs will be relevant as sources of expertise. Investors and shareholders will, of course, be influential stakeholders in this process. But where we're looking at impacted stakeholders, those are the groups that really matter. And we need to see that kind of clarity, you know, coming through, and that recognition of the differentiated roles and relevance of different stakeholders in human rights due diligence processes. Second point, as we look ahead, is that, as I've said, it's not clear how these more results-based measures on forced labour will interact with the due diligence standard of conduct. The logic in the guiding principles and in human rights due diligence is engagement with business partners and others in the value chain in order to drive improvement over time. The logic is the opposite of cutting and running. And there is a risk that measures that are about purely about achieving a certain result could, if poorly designed or poorly implemented, incentivize cutting and running. And that's something that I think anybody who cares about this agenda wants to avoid. Finally, on reporting, it's quite clear that companies that have already invested in using the GRI universal standards, this will really help them with compliance with reporting, but still some questions about how the detail of EU standards will align with what's going on internationally. Let me stop there. Thank you very much. And back to you, Brian.
Thank you, Rachel. There is obviously a tremendous amount happening outside of North America. And it is very significant in terms of trying to find this balance between economic development and social progress, something we've never done on a globalized scale. So let's turn now to Chris Pigott. As I mentioned before, Chris is going to focus his attention on North America. Chris is a leader in the Canadian legal community in the business and human rights, the BHR field, which I like to repeat, is actually the S, the social, in ESG. So Chris has appeared in many of the leading Canadian court cases in the BHR space, up to and including the Supreme Court of Canada. He advises the Canadian business community on new BHR developments, and he is frequently called on to respond on behalf of business to government initiatives in this area. So from this perch, let's hear about North America from Chris. Chris?
Thank you very much, Brian, and happy to be here. Chris, can you put up my slides, please? Thank you. And we can move right into the next slide. And so I'd like to start by saying that in North America, Rachel's comments have really helped set the stage for where we might be going, but where we are not quite yet. We are in North America, both in Canada and the US and Mexico, certainly at an earlier stage in development when it comes to the implementation of the UNGP and business and human rights principles more generally in domestic legal frameworks, and I would say in what I would call corporate culture. But we are beginning to see quite rapid and meaningful change really across North America in the BHR space. We're seeing a number of trends that, as I just suggested, really do appear to be pushing us more toward perhaps not the same place that the EU is in right now, but a place that looks a lot more like the EU. So what kinds of trends are we seeing by way of preview in North America? Well, we're certainly seeing a move from a world of soft law, voluntary compliance with non-binding principles, to harder legal obligations embodied in domestic legislation, and in Canada at least, judicial decisions by much more interventionist courts in the human rights area. We're also seeing a gradual push to far more extensive reporting and mandatory reporting obligations and potentially due diligence standards. And this is reflected in national legislation at both the Canadian federal level and at an earlier stage at the US federal level. And last but certainly not least, we are beginning to see far more litigation in domestic courts concerning alleged human rights abuses by companies committed abroad. And I'll talk briefly about an important Canadian Supreme Court case called Nevson that came out a couple years ago that is really beginning to have an impact on the ground in the North American business and human rights world. Next slide, please. First, let's start with some important legislative and regulatory developments. And I want to begin with a development that is not new. It's something that happened actually about a decade ago in California. And that is the California Transparency in Supply Chains Act, which came into force in California in 2012. The California Act was really the first piece of legislation, of hard law, that came into play in North America related to human rights reporting in the area of modern slavery. The California Act, in some ways, set the stage for more rapid and far-reaching developments that we're seeing today. What did the California Act do? Well, it really mandated transparency, mandated disclosure across 5 key areas. First of all, verification. Companies needed to post on their website what they were doing, if anything, to try to evaluate and address the risks of human trafficking and modern slavery within a product supply chain, whether developed by within that company's supply chain or down through its remote contracting supply chain. Second area for disclosure was auditing. What's the company doing to audit suppliers, to evaluate compliance with any company standards on human trafficking and modern slavery? Certification. Does the company certify direct suppliers, or do direct suppliers certify that their products and the contractors that they may be working with comply with relevant human trafficking and modern slavery policies, whether in the home country or in a supplier's home country in a foreign jurisdiction? The fourth area for disclosure relates to internal accountability. What internal standards, internal procedures does the company have, the reporting company have, to ensure that employees and contractors are aware of and held accountable to standards around human trafficking and modern slavery? And last but not least, what sort of training does the company provide to its employees, to its suppliers, concerning human trafficking and modern slavery, and how to prevent human trafficking and modern slavery? Those are the 5 main areas touched on by the California Act. What's interesting about the California Act in retrospect is that it just mandated disclosure on the corporate website. It did not require a company to take any new steps to implement new measures to address human trafficking or modern slavery. It really was a pure reporting law that really hoped to, through sunshine, to put pressure on companies to up their game in the area of modern slavery and human trafficking prevention in their supply chains. So it's an early example in North America of how companies were being required through legislation to implement business and human rights principles. Fast forward 10 years, and we'll move north of the border to Canada. Canada has been a bit of a laggard, to be frank, when it comes to the implementation of the UNGP and business and human rights principles more generally. There have been a number of attempts over the last 10 to 15 years in the federal parliament by minority parties to introduce legislation that would implement some sort of modern slavery protection, particularly in the extractive sector, where Canadian companies are dominant, frankly, internationally. But those legislative attempts always failed and usually had no chance of success. That has changed quite recently with a piece of legislation currently in Parliament called Bill S-211, which is titled the Fighting Against Forced Labor and Child Labor in Supply Chains Act. Interestingly, this is a private member's bill. It was not introduced by the government, but the Pierre Trudeau government has taken a keen interest in the legislation and has decided to actively back it. So this legislation will become law. The question is when. We expect that it will pass sometime early in 2023, which will mean that it will then come into force on January 1st, 2024. Unlike failed examples in Canada of extractive sector supply chain due diligence legislation, the Bill S-211 is a comprehensive piece of legislation that applies quite broadly to virtually any business doing business in Canada of any size. The main requirements to be covered will be that you're either listed in a stock exchange in Canada, or if you're a private company or a subsidiary, a private sub of a listed company, you meet certain financial thresholds, which are fairly minimal. You know, things like $20 million in revenue or $40 million in assets. So legislation of a very broad scope. What will the legislation require of a covered entity? Well, the main requirement, at least on the face of the legislation, and I should point out that at this point, we don't have any regulatory or interpretive guidance from government on how the fairly broadly worded legislation will be implemented. At this stage, on the face of the legislation, the main requirement is going to be that a covered company must produce an annual report on the steps that it has taken over the course of the past year to prevent and reduce the risk of child and forced labor in its supply chain. Now, the legislation sets a very detailed reporting requirements as to what must be included in the annual report, which must be submitted to the federal government and published in a prominent place every year on the company's website. Some of the main information that's going to be required is as follows. The company must report on its structure, activities, and supply chains, broadly speaking. What kind of business is it doing? Where is it doing business? And what kind of supplier companies is it working with worldwide? What policies and due diligence processes does the company have in place in relation to forced labor and child labor in its supply chain? So not just what sort of policies does it have, but what due diligence is it taking, if any, respecting forced labor and child labor? The company must also report on the parts of its business and supply chains that carry a risk of forced labor or child labor, and the steps that the company has taken to assess that risk and what steps they've taken to manage that risk. The company must report on measures that it's taken to remediate forced and child labor where a risk has arisen, and including what steps it's taken to remediate any loss of income to the most vulnerable families that result from any measures in this regard. The company must also report on the training that it provides its employees on forced labor and child labor, and interestingly, how the company is assessing the effectiveness of the steps it's taking with respect to its efforts to preventing and reducing forced and child labor in its supply chains. So in short, and to summarize, very extensive and very broad reporting requirements that stretch to the very end of a covered company's global supply chain. The consequences of non-compliance with the reporting obligations in the legislation, and indeed the importation of any goods made with forced labor or child labor, are quite severe. So first of all, with respect to non-compliance with reporting alone, the legislation gives government extremely extensive seizure powers, discovery and inspection powers to try to identify forced or child labor in a product. If the company fails to comply in any respect, any meaningful respect with reporting obligations, it's liable for a fine of up to $250,000 per occurrence. Now, last but not least, and to touch on a point that Rachel referenced in her comments, there is a results-oriented focus when it comes not to reporting, but the actual identification of goods that may be imported into Canada that were produced with forced or child labor. There is a lack of clarity as it stands on exactly how government is going to manage the process for identifying, seizing, and ultimately releasing any such goods. And it is, I would say, a troubling lack of clarity at this point in time. The Canadian Border Services Agency and other relevant federal government departments have not even yet developed standards for identifying at-risk goods that it's concerned about, whether on a sector-specific basis or other basis. And so we're really still at the stage where government is trying to figure out how it's going to implement any bans on importation of goods. So that is a big wait and see that we'll be watching with interest over the course of the next year as the legislation is enacted and ultimately comes into force, likely on January 1st, 2024. Next slide, please. A brief comment about other North American developments on the horizon. And I just have a few moments left, so won't spend too much time on these, but they are potentially important. First of all, development earlier this year in the US Congress. Bipartisan bill called the Slave-Free Business Certification Act was introduced in February 2022. This is a piece of legislation that interestingly goes beyond the sort of reporting obligations that we saw in the California Act and even in the Bill S-211 in Canada, because it not only requires extensive reporting obligations, but it actually mandates quite an extensive audit process that a covered company must go through prior to producing a report. And the legislation would require that the annual audit a company must undertake will include things like interviews with a diverse section of the company's workforce and a review of relevant documents, including, among other things, employee pay stubs, age verification procedures, worker contracts, third-party worker-broker contracts, time records, recruitment procedures. So really, the whole litany of human resources, documentation, and practices that are used to manage a global workforce. Those would all needed to be audited on an annual basis before the company produces the required report to the US Department of Labor, reporting on what it found in its audit. We're also beginning to see other regulators get involved in the business and human rights reporting and due diligence world. Perhaps most interestingly, over the course of 2022, we've seen the American Securities and Exchange Commission, the SEC, dip its toes quite forcefully into this world. Really, the first shot, as I see it at least, was the introduction in March 2022 of proposed climate risk disclosure rules by the SEC. Now, these rules are quite controversial and have been heavily contested by a variety of groups across the US. They have not been implemented yet, and it's not clear when and in what form they will be implemented. But what's interesting to me is that there's also been discussion in and around the SEC of beginning to require similar human rights and human capital disclosure requirements. So that's something that we should all be keeping our eye on, because as soon as financial regulators like the SEC in North America begin to become involved, this is where we see, I think, real teeth on the implementation and enforcement side. Next slide, please. And last but not least, before I turn it over to Brent, I just wanted to comment very briefly on an important Canadian court decision that was issued by the Canadian Supreme Court 2 years ago. The decision is called Nevsun Resources. And quite apart from the findings in this decision, I think it's quite important because it really signaled, in Canada at least, that courts were now engaged, involved, and going to intervene in human rights issues that arise in global supply chains. Very briefly, this case involved claims by a group of Eritrean nationals against a Canadian mining company, Nevsun, for alleged human rights abuses that had occurred at a Nevsun mine in Eritrea. There were allegations of forced labor by Nevsun subsidiaries and contractors. The plaintiffs brought a claim in the Canadian courts in British Columbia based on traditional tort law of negligence and the intentional torts, things like assault. One of the things they did, though, was relied on principles of customary international law, including prohibitions on forced labor, torture, and slavery, to really infuse and inform how they said to the court tort law should be interpreted in this context. Now, in the lower courts, these claims were rejected and not allowed to proceed. But the Supreme Court overturned one of these decisions and said, first of all, this case could proceed in the British Columbia courts, despite the fact that it had occurred. The facts had occurred in Eritrea, because there was very little chance of the plaintiffs finding justice in Eritrea for a variety of reasons. But second, and even more importantly, the Supreme Court found for the first time that principles of customary international law, which are widely accepted and established norms around things like slavery and forced labor, are automatically adopted into the Canadian common law. And on this basis, a Canadian court can find that a Canadian company has committed an unlawful action abroad based on human rights principles that are imported into Canadian common law. And so in this case, the Supreme Court said, plaintiffs, your case can proceed. And very shortly after that decision, the case was settled. We are still seeing the impact of Nevsun begin to unfold in lower Canadian courts. And that is really an important area for development that we'll be watching over the course of the next few years. Brian, Brent, I think I'll leave it at that and turn it back to you.
Thank you, Chris. That's terrific. And for the audience, I think you're now certainly appreciating, if you didn't already, that there is an upward trajectory to social progress. It's being achieved differently in Europe and North America, but with the same intention. I now want to turn finally to Brent Wilton. Brent is a longtime friend who is as connected to the employer community as anyone I know. This is from his time as Secretary General at the International Organization of Employers, while the UNGP was being formulated. His time at Coca-Cola as the head of global workplace rights, and now at Tuhana Consulting in New Zealand. Brent, could you take a few moments just to reflect on the impact of these developments that Rachel and Chris have drawn the audience's attention to on corporate behavior? Brent.
Thank you, Brian, and hello everybody, and thank you for having me. I haven't got a lot of time and I don't have slides, so you're going to have to look at me instead, I'm sorry. But I think in terms of what you've heard from Rachel and Christopher is that it's very hard to generalize. Companies of different sizes, of different sectors and different countries are experiencing all of these trends in different ways. So I think it's very important for every company to consider itself in terms of how it goes about dealing with these expectations which are coming down the line. I think it is clear from what we've heard that the expectations are increasing on business, that businesses are at various stages of their understanding of what this means. Many countries are still dealing with basic challenges of compliance with regulatory requirements without even looking at going beyond that into the area of human environmental due diligence. We're seeing now some movements also in Asia in this regard, with Japan looking at legislation, but we've yet to see what Latin America or even Africa may come back with in terms of how they view these trends impacting on their economies. I think one of the challenges that business faces with all of these expectations is how do they deal with their value chain and its implementation. There are concerns out there amongst the small and medium-sized enterprises in particular that this will be visited upon them, that the requirements that business has to meet at the top of the value chain will be demanded of those in the middle and at the lower ends of the value chain, with little understanding as to what this really is about, very little capacity and resources to implement it. And so companies are going to have to be thinking about how do they engage with their supply chain, their value chain, and the actors therein, if they're going to be successful in meeting some of these expectations. The UNGPs, coming back to what Rachel and Christopher said, and also Brian, they are a very strong center point for these discussions. But increasingly, as we're seeing individual countries put in place legislation, there is requirements for those companies operating in those markets to meet those requirements as a compliance matter. And so it's very important that within a business, the UNGPs remain the North Star, and that you look at how you're going to respond to these domestic requirements without losing sight of what the expectations of the UNGPs are. And that is why, although today we're talking about the S in ESG, it is very important increasingly in my mind that companies look at ESG as a word, not a series of letters, and that they start to take a landscape approach across their business in order to make sure that these issues are being addressed, not in silos, but across all responsible parts of the business. Now, Rachel very clearly set out that there is a range of different due diligence that companies undertake. It's very important now that they start to build the internal structures to align that due diligence, because then it will help any reporting that has to happen. But it also means the business has a complete view of what's going on. And that will be necessary, particularly now, as Rachel also mentioned, that director liability, and also, as Christopher said, in the US, liability for these decisions is coming up to board and chief executive level. So how are you going to do that within a business? The other challenge companies will have in implementation is belief. Will people believe what you're doing? And I think this is a very important part of all of this work, because reporting is increasingly required, and reporting is increasingly occurring to some companies, not all. And the question becomes, what is that reporting for? Is it a compliance report, or is it actually a due diligence report? Because they are two different things. Going forward, I think you will find that stakeholders, communities, your employees and supply chain partners will be looking for more than just the good news about how wonderful a company might be across various indicators that they are using. They're going to want to know what went wrong, what did you do about it, how was remedy put in place, etc., etc. So that new sort of reporting is going to be a challenge. And of course, again, this comes back to capacity internally as to whether or not a company is going to be able to meet those expectations. And how do you as a company draw from your value chain the stories you need to tell in order to make your reporting meaningful in terms of what the expectation of readers might be. There is a huge need for this alignment piece, as Rachel said. Alignment is going to be vital if this is going to work. But as I said before, it's going to be clunky. There are so many different things occurring at different speeds and in different places. But if you keep the UNGPs as the North Star, you have a good chance of being able to navigate your way through this and to continually adjust your business to meet the expectations of any regulatory requirements coming through. The other challenge, though, and Christopher's mentioned this, is the role of the courts. All of this is going to be subject to interpretation. All of this will probably be litigated over time. And so the court law or the case law is going to be important for companies also to manage. So the question then becomes, how on earth do you keep up to date with this stuff? And that, again, is going to be a big issue for companies to deal with. So being close to partners like Shift or through the local employers organization or business association will be important for you to be able to keep track of what is going on and how to measure it. Collaboration will also be important, again, to avoid silos. Collaboration with other companies operating in similar markets, doing similar things in order to try and jointly lift the boats will be an important step forward as we deal with this. I'm very conscious of time, and I want to leave a few minutes if there are any questions that need to be asked. But one of the things that really comes in here is the role of governments. Under UNGP, it's Pillar 1. Governments have a huge responsibility here to help business, not only to understand what these requirements are, but to give them resource support to enable them to meet those expectations. I would have to say that my experience of the role of governments in this space has been pretty poor. If you look again at the OECD guidelines, which also reflect the UNGPs, the number of those countries that have actually taken the steps of informing their business communities around the M&E declarations is minimal. And so there's a big gap there that governments will need to step into, particularly to give that information and advice in a timely manner, but also to help the smaller companies deal with this. I think there is a real risk in this as well, that we may see some more economic nationalism come into play as people perceive risk as something that they need to limit, and that people start to onshore more of their value chain, to move out of markets that previously they supported through their value chain operations. And that can have very negative effects on people, not just in an economic, but also in a human rights sense. So again, in conclusion, there are a lot of things that business has to manage in this process. As I said, each business is different. If you are a large company operating in all markets, you will have one response. If you're a smaller company operating only in a few markets, you may need a different response, but you need a response. And I think it's now important for companies to start thinking about how can they use the UNGPs as a starting point to start to get their commitment around human rights right, so that when this value chain is visited upon by the buyers at the top, they have a response which actually means they are able to ensure their future within that value chain. So, Brian, I'm going to have to stop there, conscious of time, but thank you very much for the opportunity. Sorry it's so rushed, but there's a lot going on.
Brent, before we have a few moments, and I've been checking the Q&A box. I want to start just with a quick question for each of the panelists. And for you, Brent, just spend a little more time on what are companies looking at in terms of internal means of managing these very complex issues as they're unfolding?
I think we're seeing increased internal collaboration across various departments. I mean, it is still clunky because different departments are running against different KPIs. So if procurement's got a KPI to buy as much as possible for as little as possible, that can conflict with other parts of the business that is looking to try and create a sustainable supply chain with a living wage for people at the bottom. So there is a need for that internal alignment. There is also a need for some integrity in the process. And so one of the things which is being played around with, and some companies are looking at this, are things like a chief integrity officer, someone who actually has an independent, almost like an ombudsman role within the business, to be able to actually marshal the forces that need to be brought to the table in order for these issues to be addressed and to report that through to the board in an integrated way. It's still developing. Companies are doing this in different ways, but I think the key going forward, Brian, is that internal collaboration. Get the responsible people in the room at the same time to have the same conversation and set some common standards that they wish to pursue and common KPIs to support it. Thank you, Brent.
Rachel, could I just pick up on one feature of your presentation, and that is, what's the current discussion in the EU on the role of the board in overseeing a new due diligence duty? And I think this sort of ties in with what Brent just talked about in terms of internal organization.
Absolutely. And I think Brent's points about what's needed internally as this issue gets elevated to board level are absolutely right. And he speaks from direct experience there. The debate in the EU is sensitive on this topic. I think there are some member states that feel that they already allow and are clear that directors should include sustainability considerations as part of meeting their duty. They don't want further specification in an EU law on that. There are other member states where that would clearly be helpful. I think nobody's saying that this isn't allowed. It's the difference between having it implicit as part of directors' duties to act in the best interests of the company and making it explicit. But whether or not that specific provision gets through, the fact is that directors will have to include oversight of due diligence processes as part of what they're concerned about, because this will be a new corporate duty, and that will have implications for them.
Thank you. Thank you, Rachel. Finally, Chris, just very briefly, we hear a lot in North America, the United States has sort of moved ahead in terms of legislation and regulation around withhold release orders, for example, where there are thousands as opposed to one in Canada. Are there other ways in which you see that Canada is actually responding more quickly than in the United States?
It's a good question, Brian. And I think perhaps not unusually, in the US, we often see faster activity on the legislative and regulation front, driven often by domestic pressures, sometimes informed by abroad. China is an important factor in the business and human rights world in the US. Canada, we've tended to move more quickly on the judicial front. Our Supreme Court in particular, but lower courts too, have always been very attentive to what is happening on the international stage, both in the EU courts, but also at the supranational level within the official sector. And so certainly in the Nevsun case, but in also some of the major labor rights cases we've seen over the past decade or so in the Supreme Court, the court has been making decisions that are, if not based on, heavily informed by ILO principles, developments within the EU courts, and a more generalized sense of what's happening around things like the UNGP. So on the judicial front, I think Canada's far ahead of the US.
Thank you, Chris. On that note, let me do two things. First, I want to thank all of the participants for attending. I hope you have found this helpful in terms of, as I said at the outset, maybe the least understood of the three components of ESG, the social. You have been listening to three experts, Rachel, Brent, and Chris. I want to thank those three, and I hope the participants virtually will join me in thanking them for sharing their expertise. To everyone, have a good day, and thank you very much for attending this ICGN event. Thank you.